Hello, and welcome to episode 27 of Privacy Laws, where I, Donata Strang Skilbert, speak with amazing privacy professionals, and we have some laughs along the way as well. Today, I'll be speaking with Matthew Baker about a recent decision by the European General Court affirming the EU US data privacy framework. Matthew is the chair of Baker Bott's Privacy and Cybersecurity Practice, a certified information privacy manager, and a certified information privacy professional for the US and European jurisdictions. Matthew's practice spans data privacy, cybersecurity, crisis management, and incident response, and he helps clients navigate the complex web of regulations, advancing technologies, and cyber threats. Matthew, thank you so much for joining me today.
Absolutely. I'm happy to be here. Thanks for the invite.
Of course. So you chair your firm's privacy and cybersecurity practice group. What are the advantages of having a practice group that focuses on these fields specifically?
Yeah, that's a great question. I think in today's environment of constant data threats and evolving privacy laws, having a dedicated privacy and cybersecurity legal team is extremely valuable for clients. I see a few big advantages to having these types of dedicated practice areas. And the first is really about specialized expertise. I think privacy and cybersecurity law is complex and fast moving, and it requires a really dedicated focus. And by having a team that veritably eats, sleeps, and breathes these issues, we can ensure that no detail is missed and that we're well versed in the nuances of relevant laws and standards, especially as technology and innovation push forward as rapidly as it has been. I
Mhm.
also think that having these dedicated practice groups helps with navigating evolving regulations. So privacy rules are constantly changing, as I said, and emerging across all jurisdictions. And they can be nuanced and they can be different. And so having this dedicated practice where people are staying on top of all this helps to serve our clients' interests and help them stay compliant and resolve risk.
Yeah,
On the
I
cyber side
totally
of the
get that.
house, on the cyber side of the house, I think having a dedicated team helps with incident response readiness. Data breaches and cyber incidents require immediate, skillful handling. And having a dedicated privacy and security team means our clients have a breach response counsel on call who's experienced in managing these crises. And I know a lot of different firms and a lot of practice areas have crisis management and incident response. There is a difference between physical and cyber, and having that really necessary expertise is critical. And finally, I think the multi-jurisdictional approach and strategic insight is really valuable here because privacy really it touches on all kinds of areas. It's practice agnostic, it's industry agnostic, and it takes not just legal acumen, but also technical and business awareness, but also cultural awareness. And so having a really dedicated group that's experienced in working with companies and organizations that operate in multiple jurisdictions in multiple different areas on a global platform helps to understand the way that what clients are doing with personal data has an impact on the end users or the data subjects. And we want to make sure that those are protected and that trust is embedded in what companies do, whether it's for external data subjects or internal ones. So these kind of dedicated privacy and cybersecurity practice groups, I think they provide really specialized knowledge, agility, and just comprehensive support that companies need in today's digital landscape.
Yeah, to me, the specialized knowledge is so important. I mean, I can't say how many instances I've run into this where a business says, "Well, we're just going to have our business or our contracts attorney write our privacy policy,"
Right.
and then you look at that privacy policy, and it's like, we have all these cookies running on your site, on our site. We have all these advertising trackers, all these analytics trackers, and they would never collect your personal data. And I'm like, hold on a minute, like we're running into an issue that's almost like malpractice here.
Yes.
Because if you don't understand how these cookies and scripts work, or you don't understand how websites work, and you're just saying, oh, we don't collect any of your personal data, or oh, you don't need to worry about CPRA because your business is not located there, or you
Yeah.
don't need to worry about GDPR because your business is not located there. To me, that's, very close to being incompetent. So I always caution people, if you are going to try to use your business attorney for this, make sure that they have a thorough understanding of privacy laws and that they track them and they track rules, regulations, and enforcement actions. Because, like you said, there's so much going on in this field. And it's kind of like me being a privacy lawyer. I'm not going to offer somebody to do somebody's divorce because I just don't understand enough about it. So having that specialized knowledge is really, really important here for sure.
I couldn't agree more. And I will say that I see a lot of issues arise from a risk perspective with clients that, have had people or lawyers or even non-lawyers help them with compliance aspects. And that tends to, down the road, get people into trouble. And it's often because the nuance in your example is that we as privacy and security legal professionals often operate as a conduit or a translator, if you will, from the legal to the technology and the business. And we can help translate and understand all the different stakeholders and how they operate and what they need. And if you're a lawyer looking at just the text of regulation or the text of a law or the text of best practices, but you don't understand the technology, you're overlaying a simple idea over a complex process. To your point,
Mhm.
cookies and what they may or may not collect or do on a company's website, and what risk that starts to increase or raise.
Yeah, absolutely. So if somebody's working in a firm and they already have a number of privacy or cybersecurity specialists, but they don't have like a practice group in place, what advice would you give them if they want to form a practice group in their firm?
Yeah, that's a great question too. I think I've got a couple different ideas about this. And the first one, after having been the chair for many years now and understanding how different lawyers operate and different client needs arise, I've got a couple ideas about how a successful privacy group can come together. And the first, I think, is making sure you've got enough cross practice experience, because a privacy lawyer isn't just a privacy lawyer unto its own
Yeah.
right, his or her own right. Right? We all have our own foundational legal precepts. Myself, my background is as a litigator, but I have people within my group that are also IP lawyers or corporate lawyers. And that has been incredibly valuable because we all pull from different skill sets when we, again, overlay privacy, AI, or cybersecurity on top of a deal or an enforcement action or a cyber incident or some piece of litigation that might arise. And that is really valuable. So having lawyers that not just have the privacy expertise, but that can build upon and lay that expertise upon a more traditional and foundational legal training is really critical in my view. The other thing is, as I said earlier, I think privacy has become and security has become industry agnostic. I think for a long time it was more thought about in the more consumer space, but it affects every business now globally. And I think having lawyers that understand different industries and practice areas is really, really helpful. The next thing I think is having, I'll say this and then I'll explain it, having a single pillar practice. And what I mean by that is not pulling apart privacy and security or even AI and putting them in their own practice areas. From my experience, when clients come to a firm or any lawyer and they need help, they don't need three or four lawyers touching a matter because each of us has discrete expertise in that singular area. Privacy and security and now AI are becoming so inextricable that it's really important to have everybody working together so that when we are reviewing either regulatory issues or compliance best practices, or even when we're helping a client in a deal or in connection with a piece of litigation, being able to issue spot is really critical. And being able to do it with a singular team is even more important for a client. It creates a lot of efficiencies and a lot more protections for clients. And then in connection with that, I think there's a really interesting aspect that, in my view, some firms don't think about often enough, and that is on the focus of talent retention and development, in particular young lawyers. So if you've got this single or singular pillar for a practice group where you're all looking at privacy, security, and AI as a holistic topic, it helps, I think, develop and retain talent so that you can look at succession planning, you can look at scalability within your group, which I think is also really critical, not just for longevity of a practice, but also for great representation of clients.
Yeah. No, that's really great advice. I think it's interesting that you note that, like for us, and no offense to you or myself, but like older lawyers, we all started as something else.
Yes,
So, we all started in like litigation, or we did contracts, or we did business law. It'll be really interesting to see how it works when some of the newer lawyers, they start immediately as, working in privacy.
they
They
do.
didn't do something like tangential and then found privacy and fell in love with it. They just started there. So I think that'll be really interesting to see.
You're absolutely right about that. It gives me a little pause if I'm honest. And I try very hard to bring my associates that do sit in the privacy and security practice group into other matters so that they can
Mm,
see how a deal functions or how litigation works more generally. So they can leverage those opportunities and leverage that experience as they continue to grow and develop in privacy and security. And frankly, I've even talked to some young lawyers that leave firms that are too siloed. And that's what I meant by, again, that single pillar,
yeah.
bringing everybody together. They feel like it's too siloed. They're only focused on one thing, and it might feel like you're not giving enough to your training and development, and therefore don't have enough to offer or provide to a client when they come to you for these big,
Yeah.
broad, wide scale issues.
Yeah, I could see that being discouraging and boring for somebody,
Mhm.
if and also hard to give clients advice. Sometimes the clients will ask us like, what's the risk of me being sued here? And what
Yes,
would that look like? And if you know nothing about litigation, you can't give them an answer. So it's
that's
good
right.
to give them a broader perspective for sure.
Especially
Um,
as the area of privacy, which used to be much more about simple regulatory compliance and advice on innovation. But now we have such a grip within the plaintiff's bar where they're using all kinds of different mechanisms to litigate privacy issues. And then, of course, we now have more global regulators that are picking their head up and creating more enforcement action. So you've got that to deal with as well. It's just
mhm,
become a much more multifaceted legal precept and
for
practice
sure.
area.
Yeah, absolutely. So let's get into talking about the European General Court decision. So that was regarding the EU US data privacy framework. So, what was the legal challenge to the DPF that Latome brought, and what were his main arguments against adequacy of the DPF?
Yeah, this was an interesting case that came down, especially in light of the predecessor cases, the Schrems cases from the Court of
Mm,
European Justice. So Philippe Latoum brought a challenge in his own right about the Commission's adequacy decision that they granted the EU US data privacy framework. He basically sought to annul that July 2023 decision, which ultimately greenlit the DPF, as a valid mechanism for transatlantic data transfers under the GDPR. His primary arguments were there. He had a multitude of arguments, and I'll just touch a little bit on each of them, and then we can certainly get into details if we need to. But first, Latum's central claim was that the U.S. surveillance practices, they still fall short of the EU's privacy standards, those under the General Data Protection Regulation, despite reforms that were introduced by Executive Order 1486. He basically argued that US intelligence agencies retain overly broad powers to access personal data of EU residents, especially under laws like FISA Section 702, which is our Foreign Intelligence Surveillance Act. He also claimed that there was a lack of effective judicial redress for EU citizens. A core pillar of the DPF is the Data Protection Review Court, otherwise known as the DPRC. And it's a new mechanism for EU individuals to challenge surveillance misuse. And Latum claimed that this wasn't essentially a genuine court. And we can talk about that in a little more detail in a moment. He also argued that there was no protection against fully automated decision making. And I think this is really interesting because it obviously comes in light of such incredible advancements with generative AI and other types of artificial intelligence. So he basically argued that the DPF fails to guarantee protections equivalent to Article 22 of the GDPR, which is the automated decision making provision. And it prohibits significant decisions based solely on automated decision and processing of personal information associated with those decisions. So the last argument that he made was that inadequate oversight of legal remedies for EU residents. He argued that the DPF lacked meaningful enforcement and oversight, and this is because the US made commitments via an executive order, which isn't binding legislation here. The oversight bodies like the Privacy and Civil Liberties Oversight Board and the DPRC lacked structural guarantees of independence, and that individuals had no transparent, accountable processes to pursue redress or legal violations, which is indoctrinated into the GDPR. So, in essence, Latum believed that the DPF did not truly fix the problems that led to Schrems 2, which is all about the excessive US surveillance and ultimately dismantled the privacy shield.
Mhm. Yeah, I think some of those have there's definitely some good arguments in my opinion there. It took so long and so much effort to get to the DPF from our political system, but we still don't have a comprehensive federal privacy law that offers privacy rights to everybody. I was reading a federal privacy bill that was proposed 2 days ago, and it's like 2 pages.
Yes.
Some of it is like, man, y'all could put like a tiny bit more effort into this, but we all know it's not going to pass anyway. So really, what does it matter?
What's the point in reading these things? There have been so many over the past several years that have not come to fruition yet.
Yeah. Part of my job is tracking these, and it's really funny because there's a bill and one year it doesn't pass because there's all this contention about it. And next year they propose the same exact bill with the same exact text, hoping that somehow by magic everybody's going to agree to it
Yeah.
now. I've seen bills where you have what do I say, like you have to collect the personal information of 10,000 or more residents of the state for this law to apply to you, but instead of the 10,000 there's an X. Like, who proofreads these things?
Yes. And it's so difficult. You are pointing to many of the thresholds that are indoctrinated into state-based comprehensive privacy laws. And it is
Yeah.
so difficult for companies to understand unless they are counting and tracking and can have traceability around every single data subject, which is so
Mhm.
difficult to do, how would one organization versus another know this is applicable to me and not applicable to me? It's a very challenging environment when you make those applicability thresholds into more concrete numbers.
Yeah, absolutely. Because when somebody submits a contact form on your site, they're not going to say, "Hey, I'm a resident of Maryland
That's
and
right.
I'm interested in your services." People just don't do that. So yeah. But anyway, getting off topic here. The U.S. Redress mechanism. How did the court address that?
So the redress mechanism being the DPRC, I think is that what you're referring to?
Yep. Yeah.
Perfect. This was an interesting one because as you noted earlier, there were some really strong arguments that Latum brought to the court, and I think this is one of them. Basically, Latum was arguing that a core pillar of the DPF is this data protection review court, which is a brand new mechanism for EU individuals to challenge surveillance misuse. And he claimed that this wasn't a genuine court. And that's because it's not part of the US judiciary. It was created through the executive branch, again, by executive order. And that DPRC members are appointed and overseen by the US Attorney General, which is compromising their independence and impartiality versus, for example, in the actual federal judiciary where they're appointed, especially for on the district level, it's a lifetime appointment. And then finally, he was claiming that EU data subjects in particular lack direct access to that court. They can't appear, they can't be heard, and they don't see the evidence used in any of these decisions. So his position is that this court, it lacks procedural guarantees that the EU requires to be an effective remedy.
What did the court say about that? I mean, why did they find it to be sufficient?
So the court essentially said that there were no to be essentially substantially similar, that it didn't require courts to be necessarily part of the judiciary, that the act of having a redress mechanism on its own was sufficient, even though EU citizens might not be able to, for example, appear directly in court. But that the idea of being substantially similar or an essential equivalence, which is the phrase used under the GDPR, didn't require an exact copy or idea of what the EU redress mechanisms should be or should look like. It's that they are substantially similar or essentially equivalent. And that's where the court came down on, especially with respect to the DPRC.
Got it. So it's like you have something. It might not be effective, it might not be the best, but there's something in place, so we're going to count that as good enough basically.
That is exactly right. And it's really important to note that when the court reviewed this challenge and this claim, they specifically said that they were looking at the commission's decision from July 2023 and all of the relevant information at that time, and not what it might be like now in 2025 when they ultimately rendered the decision. So there's this interesting gap between when the commission granted the adequacy decision and when the DPRC and other oversight mechanisms were established via the executive order and what they actually operate like now, today, and how they may have changed over time, in particular with changes in our political administration. and what might be happening from a political perspective. And so to me, that was two things. It was a way to be deferential to the commission, which I think is interesting because the Court of Justice in the Schrems cases were not as deferential to the commission's decision, but this definitely was. But it was also this really interesting way of sidestepping a number of things that I think we all understand happened when the administrations shifted over from more of a political perspective than simply a legal perspective.
Mhm. Do you see any gaps or vulnerabilities in the court's reasoning in this decision that could potentially be challenged on appeal?
I, I do. To me, the biggest ones are that, first and foremost, the DPF relies almost exclusively on the executive order, EO 1486, and that it's not an enduring piece of legislation, statutory law, for example, and that a number of the oversight mechanisms are quite politically contingent and not structurally entrenched. And so, as we said very early on, I think some of these challenges and the arguments that Latoum made were decent ones, strong ones, because we can
Mhm,
already see some of the dependencies of the executive order breaking down and some of these oversight mechanisms potentially unraveling. And I think that what's going to happen is there will be a challenge, I think, an appealable challenge to this. And if we're taking cues from what the Court of European Justice did in Schrems 1 and 2, where they essentially questioned the adequacy decision, especially in Schrems 2, and they looked at it not at the time the commission made the decision, but what's going on now. And if they do this again, they being the Court of European Justice, I think they would likely take a very similar approach and not the approach that the current court took, which is to say they're looking at it only at a moment in time and being very deferential to the commission's decision. And a lot of that was based on because the commission has a duty to continuously review these adequacy decisions and make changes, potentially repeal or even amend the decision should that essential adequacy change or differ over time.
yeah. I think when you look at other countries that have received adequacy decisions like Canada, their systems look very, very different from ours
They
in terms of
do.
privacy protections, and it's hard to see how this current system that we have is going to be sustainable long term in terms of an adequacy decision, at least in my opinion. You have countries that have very comprehensive laws, that have very
Yes,
comprehensive systems. It's been entrenched for a long time. Everybody understands the rules and follows them, versus this kind of half baked pancake that we have
yeah,
here that we try to rebake every couple years to
that's
see,
right.
hopefully this time it works.
That's exactly right. And I think that you're hitting on something exactly what Latoum is arguing here, and what I do think is part of the vulnerability in this adequacy decision, in that it's just not enduring. You rightly pointed to Canada, and they have these statutory laws entrenched in their system. Brazil just received an adequacy decision, and they have developed a very similar GDPR like framework that is law and not just this transient presidential order that could be overturned at any moment should the administration turn over or the current administration decide this is something that no longer works for the United States. And so you see them in a very different light, and you see that the again the enduring aspect of the legal precepts entrenched in those systems, and how fragile they can be, especially in the United States, based on simply the EO and not other legislative or even court driven efforts.
Yeah. So I think you've already answered this, but I do kind of want to ask it again just to make it super clear. Should companies that are certified under the DPF still maintain fallback strategies like standard contractual clauses? I believe your answer is going to be yes, but I
You
did want to check.
you nailed it. Listen, as a privacy professional, there's no way I could look a company in the face and say, simply rely on the DPF. The court has spoken. All is good. Companies that are operating under the DPF should absolutely maintain fallback transfer mechanisms, up to and including standard contractual clauses. This is probably the best because it's that belt and suspenders resilience, and it gives a lot of assurances in other aspects too. And those are, essentially that even you might be relying under the DPF as an individual organization, but it may not help with onward transfers. So you might
Mhm.
still need to use standard contractual clauses if you do operate with different subcontractors, for example, or any onward transfers that might happen outside of the DPF.
Yeah.
I also think that SECs integrate a little bit better into now required transfer impact assessments than if you were simply relying exclusively on the DPF. I also think that regulators, especially regulators in the UK and the EU, expect these kinds of fallback arrangements because there has been so many challenges and successful challenges to these more framework based transfer mechanisms. And then I just think, you know, business continuity demands this. If you are an organization that is heavily reliant on the transfer of the international transfer of personal data, you need to really think about business resilience and continuity. Because as we saw from the Privacy Shield being struck down, it can happen quickly. And you need to continue to maintain compliance over these potentially large, continuous transfers that might be happening out of the EU and to the US. And then I think, honestly, my last thought on this is that the DPF might be legally stable for now, but Latoum has already, indicated that he intends to appeal. Max Schrems, who is a part of the NYOB, non-governmental organization, has already made comments that he's going to work with the organization to find other avenues for challenging this, other arguments and things of that nature. And so I do expect that there will be continued challenges to the DFP. And I don't think that organizations should look to the DFP to be this untouchable framework. And I do think that it would behoove every organization that is using it to think about these types of secondary measures that they may need to put in place.
I totally agree. This could very well be temporary. And like you said, the privacy shield was struck down and everybody was panicking over what to do. So it's best to have your ducks in a row now. I mean, even when I do like vendor due diligence, I do like the privacy part for any
Mhm.
vendors that we may want to use. And I look at their documentation and they're like, oh, we use the DPF. I'm like, what else you got?
What else you got? I say the same thing. Yep. Tell me more.
And I think so many of them assume, oh, we're going to spend all this money and all this time complying with the DPF. We're going to certify, we're going to put that on our website. And, privacy professionals or lawyers doing vendor due diligence are just going to say, oh, wow, green
Mhm.
check mark, we're done. That's it. We don't
Mhm.
need to look
Mhm.
into them any further. And to me, it's almost like it's not a red flag, but it's an orange flag because I know that you would have other mechanisms in place if you truly understood the situation and what's happening here. And I always look for those other mechanisms.
That's right. I couldn't agree more. I couldn't agree
Yeah.
more.
How should privacy teams in the US monitor developments for signs that the DPF could be under threat?
Well, this is such a good question. Look to your outside counsel. They will almost always be providing what we call thought leadership, developments in the law, and they can give you good state of the union, if you will, about what's happening. But if you don't have outside counsel dedicated to this space, I think there are some other pretty easy ways to track it. I think first is just continue looking at whether this Latum decision will move up on appeal to the Court of European Justice. I think this is probably the biggest existential threat to the DPF at the moment. I also think that organizations should be very keen and aware of US surveillance reforms, and frankly, reforms connected to the executive order that bolsters the DPF. What's happening there? What new things might be occurring if any of the redress mechanisms, including the court or the oversight board, lose valuable members or are shuttered even in certain ways? That's a signal to me. Something will happen as a result of that, if it already hasn't, and it's just waiting to come up on review from the commission.
Yeah.
The third thing, and I think this is a really good one too, and we should really be, I think, putting a lot more weight on this than we do. We often look to the courts or legislative bodies for these types of major decisions, but a lot of the signals often start with regulators, like the national DPAs. Even the EDPB will speak on these kinds of things, and they are very in touch with current state of play and the landscape. And they often have influence about the way these challenges start. Schrems 2, for example, was a result of the Irish DPA bringing this up to the CJEU. And it wasn't that it was a singular Max Schrems trying to advance this argument on his own or in his own right. I think those are some really critical ways of continuing to assess situations and determine the viability of the DPF or any future or prospective transfer mechanism.
Absolutely. Yeah. Just more stuff to track on our plate for sure.
Absolutely. Absolutely. It doesn't end. Like I said at the outset, having these kinds of, really complex, global, and evolving privacy regimes, frameworks, laws, guidance, it takes a lot. And it takes somebody
Yeah.
that really is paying attention to the global legal landscape around this.
Absolutely. Full circle.
Yes, absolutely.
So, Matthew, thanks so much for joining me today. This is a really interesting conversation, and I'm excited to stay on top of what's happening here.
It's been such a pleasure talking with you. I'm so happy you invited me to this episode, and thank you, everyone, for listening.
Awesome. And to our listeners, make sure you subscribe so that you don't miss our next episode.